Hello friends, in our last class we discussed certain provisions of section 9. Section 9 which was talking about restitution of conjugal right. In our today's class we are going to discuss section 10 of Hindu Marriage Act. Remember RCR, restitution of conjugal right, given under section 9. This provision is the first matrimonial relief. Today we are going to discuss section 10 which is judicial separation. This is the second matrimonial relief given in the Hindu Marriage Act. Okay, now we are going to discuss the provisions of section 10 called Hindu Marriage Act. Under section 10 the provision is judicial separation. Judicial separation, it is a separation between husband and wife. Okay, court, judiciary may impose, judiciary may give a decree for the judicial separation. Okay, now husband and wife, they have to live apart from each other. They can live. Okay, it is up to the discretion of the party. So judicial of separation, there are few provisions. Previously there are separate grounds were given for the judicial separation. So at first section 10, this right, this matrimonial relief is available to both the parties, to husband and wife as well. Both the parties, it may either party to a marriage may present, either party of marriage, it means husband and wife, legally wedded husband and wife, they are having a right to file a petition for judicial separation, may present a petition on the ground specified under section 13(1) and 13(2). So remember, there are few grounds given for the judicial separation under section 13 clause 1, 13 clause 2. Okay, 13 clause 1 and 13 clause 2, there are few grounds given. On that particular ground, suppose a petition is filed for the divorce, okay, but court can grant a decree for the judicial separation, not for the divorce. It is up to the discretion of the court. Okay, but if a petition is filed specifically for the judicial separation, court can give a decree for the judicial separation and only, and not for the divorce. So we can say it is the first step. Okay, generally it is the first step. It is a step before passing a decree for the divorce. It is a particular time period given to the husband and wife that they can decide whether they are actually willing to live apart from each other, they are actually willing to be separated from each other permanently. But in this case, under section 10, they are not going to change their status. Okay, after the decree of divorce, they may be called as a divorcee or the single or bachelor. They are eligible for the other marriage. Now here in judicial separation, they are not going to change their status. Okay, all other provisions, suppose there is a decree for the judicial separation is going on. Okay, after passing of that decree, after the decree of judicial separation, they are still husband and wife. There is not any kind of change in the status of the party. Okay, so section 10, which is talking about judicial separation, the grounds are given under section 13(1) and section 13(2). So firstly, right is available to both the parties. If a petition is filed by either by the husband or by the wife on any of the ground given under section 13(1), or in case of a wife, there are few other extra grounds are given under section 13(2). The grounds are given in the act. Grounds are adultery, cruelty, desertion for a continuous period of 2 years, ceases to be a Hindu. If a person who ceases to be a Hindu, it is a ground for divorce as well as it is a ground for judicial separation. Incurably of unsound mind, if a person, it is based on the mental status of the person, violent form or incurable form of leprosy, any venereal disease, if the person, if either of the parties renounce the word, like he became a sannyasi, or that person has not been heard for a continuous period of 7 years, that person is alive. In this situation, these are certain grounds are available to the person. There are few other grounds are available. For example, husband is guilty of rape, guilty of sodomy, bestiality. There are few grounds are applicable only in case of wife, where a wife is filing a petition for the judicial separation. So remember, section 10 we will discuss all these provisions, section 13 1 and 2 in the subject in the topic of the section 13, but here we are just talking about the judicial separation which is the separation between the husband and wife, but there is no change of status. It is the second matrimonial relief. In our next class we will discuss section 10, 11, 12 and 13 and difference between them. Thank you.